Good morning and welcome to our webinar on the European Commission's Pharma and Patent Package, today with a view or with a focus on patent law. My colleagues Philip Rektorschek, Julius Zacharias and I will try to give you a short overview on the recent developments. So one housekeeping matter in advance, on the bottom right of your screen there is a button with questions. You can ask us questions there. These questions won't be visible for the other participants, but we will follow up on these questions in advance. So I can start right away with our presentation, as time is short, with the topics you can expect today. We will talk on the draft regulations, on the unitary SPC and SPC applications and centralized procedure. Julius Zacharias will go on with union compulsory license, and Philip Rektorschek will explain new developments on Bolar exemptions. So as I already indicated, time is short, so let's start with unitary SPC and SPC applications and centralized procedure. Both drafts on the unitary SPC and the classical SPC have been published on 27 April 2023. A unitary SPC was already part of the Commission work program in 2022, so this draft regulation was not unexpected. Nevertheless, although the Unified Patent Court will start on 1st of June now in a few days, there is no unitary SPC available yet. With regard to classical SPCs, the regulation was justified as several updates on existing SPC regulations have been made over the last year, so a recast was justified in the view of the Commission. So main aspects of the new draft regulations are there. The foremost aim, of course, the simplification of the SPC system. With a unitary SPC, one SPC application should lead to one right based on a unitary patent for all UPC member states, which was not available up to now. And with regard to classical SPCs, a centralized SPC application shall be possible based on a unitary patent or European patent to streamline the SPC examination process for several EU member states. This should also help to avoid diverging decisions whether an SPC is granted or not granted in national grant proceedings. So for the sake of completeness, it is worth to mention that classical SPCs may of course also be based on unitary patents. So it's not that once you have a unitary patent, you have to go for a unitary SPC, but also you can base your classical SPC on a unitary patent. So what are the fundamental changes to the current system? Of course, the establishment of a unitary right, a unitary SPC, and of course, one centralized procedure for the SPC application for several EU member states. But this is not all. Also, legal remedies are created before the SPC or unitary SPC is granted, and also a new European authority for SPCs and unitary SPCs is established. So what's the scope of the new unitary SPC? It shall have unitary character, shall provide uniform protection, and shall have equal effect in all member states in which the basic patent has unitary effect. In addition, the unitary certificate may only be limited, also transferred, revoked, or lapsed in respect of all of those member states. So a real unitary right is to be created. Things are different, of course, with a view to classical SPCs that are applied for a centralized procedure. When a positive examination opinion has been issued for one or more designated member states, the competent national authority of each of those member states shall grant a certificate in accordance with the applicable national law. Thus, a bundle of national SPCs is established that is granted by national authorities after the centralized application was successful. I already mentioned that a new competent authority is established, and the competent authority for the application and grant of unitary SPCs, and for the centralized SPC application will be the European Union Intellectual Property Office, EUIPO, in Alicante, Spain, whose core business at the moment is the registration of EU trademarks and registered community science. There, supplementary protection certificate divisions shall be established. However, the EUIPO won't have to do all the work on its own, but it can appoint competent national authorities as participating officers in the examination procedure. So how does the procedure work? Once an application for a unitary SPC or SPC has been lodged with the EUIPO, this application is published in the newly formed register. So this is not the EPO register, but a new register for SPCs and unitary SPCs will have to be established. After this publication, third parties have 3 months to submit third-party observations. When they do so, they won't become a party to the grant proceedings. The application will be examined by an examination panel, which consists of 1 person from the EUIPO and 2 examiners from different competent national authorities. At the end of this examination proceeding, a positive or negative examination opinion will be handed down. For the conditions for granting an SPC, the regulations offer no substantial changes. I already indicated that a remedy will be created by the new draft regulations, should they become a law in the end, before the SPC is granted. So within 2 months from the publication of the examination opinion, any person may file an opposition with the EUIPO, and no SPC can be granted before the expiry of this opposition period. So the opposition, once it is filed, also has suspensive effect, which means that as long as the opposition is not finally decided, no SPC can be granted. Grounds for opposition are that the conditions for grant of an SPC are not met. The opposition panel hears the opposition. It again consists of 1 person from the EUIPO and 2 examiners from different competent national authorities that have not previously been involved in the examination of this SPC. An opposition decision shall be given within 6 months unless the complexity of the case requires a longer period. The opposition is not the only remedy, but every decision of the EUIPO may be appealed within 2 months from the notification of the decision. This is also the remedy an applicant has to take against a negative examination opinion. Reasons for appeal have to be filed within 4 months from the notification, and again, the appeal has suspensive effect. The Board of Appeal has 3 to 5 members, 2 of them should be legally qualified, and the Board of Appeal or the same Boards of Appeal that currently deal with the cases with regard to union trademarks. Finally, appeal on points of law against decisions of the Board of Appeal to the General Court of the European Union is possible. So in the end, the grant proceedings for an SPC or unitary SPC with all these remedies and all the suspensive effects can take quite some time. With regard to grant and rejection, the EUIPO is the competent authority to grant a unitary SPC. With regard to classical SPCs, things are of course different. SPCs that have been applied for in the centralized procedure are still granted by the competent national authority in each designated member state. These national authorities are bound by the examination decision of the EUIPO, with 1 exception. The national authority may deny the grant if the basic patent has lapsed or was limited in the respective member state, or if the marketing authorization has been withdrawn in the meantime. The unitary SPC can also be invalidated, of course, and there is one new possibility to do so with an application for declaration of invalidity before the EUIPO. This is admissible as long as no final decision of the EU IPO or other competent court between the same parties and on the same subject has become final. Invalidity decision, which has ex tunc effect, shall be issued within 6 months unless the complexity of the case requires longer. Also possible are counterclaims for invalidity of a unitary SPC. With regard to SPCs granted in centralized procedure, this invalidity application before the EU IPO is of course not an option because there is no unitary right, and invalidity proceedings against classical SPCs have to be handled before the competent national courts and the Unified Patent Court if it's competent. With regards to grounds for invalidity, there are no substantive changes provided by the new draft regulations. Oral hearings before the EU IPO are possible if they're expedient. The hearings before the examination panel, opposition panel, and invalidity panel are not public. Oral proceedings before the boards of appeal are generally public. And as always, the losing party has to bear the costs. What else is worth to mention? Combined applications for unitary SPC and SPC in the centralized procedure are possible. And there is a priority of this new system over classical national applications. So when a basic patent is a European patent, unitary patent, and the marketing authorization for the product has been granted through a centralized procedure, filing of national SPC applications for the product is not possible in the member states in which the basic patent is in force. Last but not least, pediatric extensions are possible both for unitary SPC and SPC. So far on that. Now I will give the floor to my colleague Julius Zacharias and Union Compulsory License.
Many thanks, Verena. Next topic on the agenda, the Union Compulsory License. I would like to start my part of the presentation with a quick overview on the background and the aims of the proposal. Then we'll have a look at some details of the draft regulation. And at the end, we'll quickly discuss the relationship and differences between the proposed Union Compulsory License and the already existing national compulsory licensing regimes. So the background of the Commission's proposal is a conflict in the status quo. Because on the one side, we have got a regulation patchwork. That means that currently compulsory licensing of patents in the EU is fragmented, as every member state has its own legislation on compulsory licensing, which is limited to each state. And on the other side, we've got cross-border value chains. So many value and supply chains operate across different member states. And from this conflict, there results the problem, which has already been also been highlighted by the COVID-19 pandemic, that it is difficult to obtain compulsory licenses covering the entire value chain because you need a separate compulsory license for each country. Before this background, the Commission has now presented a draft regulation for Union compulsory license, and this proposal aims at providing an effective tool in crisis times as a last resort when voluntary agreements do not work. It shall ensure an appropriate territorial reach of compulsory licensing to cover cross-border supply chains, and thereby it is intended to complement the EU crisis mechanisms that have been and are being established. So now let's have a look at the details of the draft regulation. First of all, the requirements. The basic requirement for a Union compulsory license is the activation or declaration of a crisis mode or emergency mode listed in the annex of the regulation. And you can see an excerpt of this annex on the right side of the slide, where you can see that there are 3 columns. The first column indicates the different regulations on which crisis mode or emergency modes can be based. Second column indicates the several crisis or emergency modes. And the third column indicates the competent advisory body for each of these situations. We'll talk about that advisory body and its role in the procedure in a minute. So the activation or declaration of such crisis or emergency mode is the basic requirement for a union compulsory license. But in addition to that, a union compulsory license would also require a need for such license in context of this crisis or emergency. And this can in particular be due to a shortage of crisis-relevant products. The general conditions of a union compulsory license are governed by Article 5 of the draft regulation, according to which the license shall be non-exclusive and non-assignable. And the scope of the license shall be limited in several ways. It shall be limited to the purpose for which the compulsory license is granted, and the scope and duration of the crisis or emergency mode on which it is based. And it shall also be limited to the territory of the union. And another interesting aspect from a pharmaceutical point of view is that a compulsory license for a patent shall also cover an SPC based on this patent, provided that the SPC enters into force as long as the compulsory license is in force. The procedure to grant a union compulsory license is initiated by the Commission, and it involves the advisory body, which, as we have seen in the annex, is indicated for each of the scenarios on which a compulsory license can be based. And the advisory body has different tasks, but one of the main tasks is that it shall provide an opinion to the Commission with regard to the need for a union compulsory license and the conditions for such license. The procedure shall also involve the right holder, and this involvement shall in particular include an assessment of possibilities to reach a voluntary license agreement so that a compulsory license would not be necessary. If the requirements for a union compulsory license are found to be met, the Commission grants the license by means of an implementing act. With regard to remedies or judicial review, we can say that implementing acts in general are subject to judicial review by the CJEU, but there are no specific provisions for such review in the draft regulation in that regard. Once granted, the union compulsory license has the following effects. It permits the licensee to exploit the protected invention within the scope of the license. And it may, this is interesting for the pharmaceutical field, it may also suspend the data exclusivity and market protection where applicable. And a further effect is that the licensee has to pay a remuneration to the right holder, whereby Article 9 of the draft regulation provides that this remuneration shall not exceed 4% of gross revenue generated through activities under the compulsory license. Another interesting issue is the question of export. So Article 11 of the draft regulation provides that in general, export of products manufactured under a union compulsory license shall be prohibited. But there is an exception for pharmaceutical products, and this exception is based on the existing regulation number 816 from 2006, which already provides the possibility of national compulsory licenses for export of medicines to non-EU countries with health problems. And according to the present proposal of the Commission, this already existing regulation will be amended to the effect that also the Commission may grant a compulsory license where the activities of manufacture and sale for export spread across different member states and would therefore require compulsory licenses for the same product in more than one member state. So the last point is the relationship to national compulsory license regimes. whereby the proposed union compulsory license is not intended to replace national compulsory license regimes, but should rather supplement them in order to be able to effectively tackle future EU-wide crises or emergencies. And there's one interesting procedural difference, because in contrast to, for example, German compulsory license proceedings, which are initiated by the license seeker as applicant against the right holder of defendant, the procedure for the grant of a union compulsory license is formally initiated by the Commission itself, which, in collaboration with the advisory body, has to select the potential licensee. So this was my presentation on the union compulsory license, and now I will hand over to my colleague Philip, who will give you some insight on the Bolar Exception developments.
Thank you very much, Julius. Yes, finally, the draft directive contains revised rules also for the concept of the so-called Bolar Exception, which is broadly an exemption for generic or biosimilar manufacturers to make use of the patent rights underlying an innovative medicinal product when preparing a corresponding generic or biosimilar marketing authorization application for their own products. These changes will be of particular interest to patent right holders, but of course, maybe even more interesting for generic or biosimilar manufacturers. Well, the Bolar exemption has been established already more than 20 years ago and provides that conducting the required studies and trials in connection with the marketing authorization application for a generic or biosimilar product or hybrids of both, and shall not be regarded as an infringement of relevant patent rights. Under the current directive, this includes any studies, tests, and trials carried out to show that a generic or biosimilar product is bioequivalent to an approved patented product in order to rely on the respective originator's marketing authorization. Although clearly stated in Article 10.6 of the current directive, meanwhile, this principle is implemented on a member state by member state basis under the respective national laws. And in this context, the Commission's new draft directive states in its recitals that the current application of the Bolar exemption is fragmented across the Union, and it is considered necessary in order to facilitate the market entry of generics, biosimilars, hybrids, and biohybrid medicinal products, to clarify its scope in order to ensure a harmonized application in all member states, both in terms of beneficiaries and in terms of activities covered. We will see in the main considerations of the Commission on the next two slides. The first objective is mentioned on page 17 of the draft. Under the headline, increased competition from earlier market entry of generic and biosimilar medicinal products. According to this, the Bolar exemption will be broadened in scope, and its harmonized application in all member states shall be ensured. And in addition, procedures for the authorization of generics and biosimilars shall be simplified. In the end, these measures shall facilitate earlier market entry of generics and biosimilars, and by increasing competition and contributing to the objectives of promoting affordability of medicinal products and patient access. And further objectives of these new regulations are mentioned in the recitals 63 and in particular 64. According to which, again, the problem is mentioned, namely that we have a fragmented picture of the legislation and in particular the application of the law, and that this shall be harmonized within the European Union. Well, what does that mean? Based on these considerations, the new Article 85 of the draft directive seeks to provide additional clarity regarding the scope of the Bolar exemption in the European Union. The slide shown contains a comparison of the currently existing wording of Article 10.6 in the right column and the newly proposed wording of the draft Article 85 in the left column. It clarifies that the following activities shall not be regarded as infringement of patent rights: studies, trials, and other activities conducted to generate data for an application for a marketing authorization of generic, biosimilar, hybrid, or biohybrid medicinal products and for subsequent variations. Health technology assessment as defined in Regulation EU 2021/2282, and pricing and reimbursement. It is worth to mention in that context that health technology assessments, including this pricing and reimbursement activities, shall now be expressly addressed under this new Article 85 by reference to the new health technology assessment regulation, which is due to come into force in 2025. And the language of the new draft seems to be much clearer than the general concept of consequential practical requirements as it is stated in the current EU Bolar exemption, which in practice led to several discussions and disputes over the actual scope of the regulation and the exemption in the past. Further, and even more important in practice, is probably the new Section B, which expressly expands the concept of the Bolar exemption to third-party suppliers and third-party service providers, which are not explicitly covered by the existing rules. This clarification may provide legal security for generic biosimilar companies who want to manufacture generic or biosimilar products that are yet subject to third-party patent rights. And at the same time, this inclusion of third parties will, of course, cause some concerns for innovators and patentees' perspectives. Probably in order to meet these, in the last paragraph, here highlighted in red, the directive clearly states that the Bolar exemption shall not cover placing on the market of the medicinal products resulting from such activities. In summary, these changes shall obviously aim a balance between providing further certainty for generic and biosimilar companies on the one hand, who are going to bring their new generics and biosimilars into the market, and by parallelly respecting the existing patent rights of the innovators and patent holders. Well, it remains to be seen whether these intentions will actually be met in practice. In any case, it seems that the position of generics and biosimilar companies will be strengthened compared to the current situation. And having said this, I may also, in the name of my colleagues, Verena Bertram and Julius Zacharias, express our sincere thanks to you for participating in today's session. Wish you a pleasant week, and please do not hesitate to drop us an email or use the question menu in case that any questions already are due or should arise in future. Thank you very much, and bye-bye.